You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. So, Mr. Cogdale, I appreciate your attorney's argument. I understand. I can see that there's some issues cognitively. However, there's no doubt that you understand what's going on, right?
Yes.
Yeah. So you've been sent to prison 6 times, and you're currently on parole for 3 burglary of a habitations, delivery of a controlled substance, evading arrest or detention with a vehicle, and then a indecency with a child. And it makes no sense to me that you were on parole and had opportunities through parole to get any help that you needed, and you didn't take advantage of that and were out doing whatever you were that you shouldn't have been doing and then ran. So at this time, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with previous convictions. Find those prior convictions true that you pled true to. Sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, you can go back with the bailiff. Jonathan, Rashard or Richard, Mr. Parker.
Competency. I'm not questioning the definitely I'm curious.
Good morning.
Wow.
Good morning, Mr. Bell. Can you hear me?
Yeah, I can hear you.
Yeah, good. Okay, so I can hear you too. So I just wanted to, you can see here in the courtroom, Mr. Parker, your attorney's here. And also Ms. Malfino with the state is here. And I have already started this hearing previously in cause number 14-18993. Mr. Bell was found not guilty by reason of insanity quite some time ago for the offense of aggravated assault against a public servant. Has been in the Rusk State Hospital, and I have received requests and information that a step down type facility would be in Mr. Bell's best interest at this time. And so, Mr. Bell, I just wanted to talk to you a little bit real quick. I went and looked at the house where you would potentially be going if I allow this. And I really wanted to ask you a little bit about what you have discussed with the social workers there and what your expectations are if you go. Do you know anything about the place where you're going?
Similar to a boarding home, I'm halfway house, like community care home, something like that. But it's a group home.
Right. So it's actually, yeah, and it's very, very nice home. And there would only be, I think, maximum 2, maybe 3 of you there. So it's not a big group home. It's just a regular house in a neighborhood. And so the most important thing to me, Mr. Bell, is that you continue with your medication. Do you understand the importance of that?
Yeah, if I take my medication, I do a whole lot better than trying to go without it.
Right. So if I let you go live at this house, I want to make sure you understand that if you miss your medication, even just one time, there's going to be someone there always, and they'll make sure you take your medicine. And if you don't take your medicine, either refuse to or skip it for any reason, then they'll let me know that, and there'll be an order sent out, a warrant for you, and you'll be right back in jail and probably right back in Rusk. You understand that, how important it is?
Understand that.
Okay. Also, obviously there's rules there, just like you've been following at Rusk, and you would be required to follow those. You understand that as well?
Yeah.
And do you have family here?
Talking about like in Beaumont?
Yeah, you have a sister around here?
But my second to the oldest sister lives in Beaumont in a brand new house. My little brother stay in an apartment. The baby of the family, John Glenn.
Yeah.
He live in Beaumont.
So it would be nice, you would be able to see them, they could come see you. I also do want to make sure you understand though, that you couldn't go stay with them unless you had permission. You have to stay and live in the house and you have curfews and things like that. You understand? You're okay with that? Okay. All right, is there anything you can ask Ms. Molfino or Mr. Parker?
I don't believe so, Judge.
All right, so I think, Mr. Bell, what I'm gonna do, I've only done this a couple of times, and you probably even know the ones that I have done this with there at Rusk and let out, and they ended up right back there a few years back. And so you probably know who I'm talking about. I don't want that to happen with you. I think it sounds like you're a great candidate for this type of home, and so I'm going to allow it. And so I just want to make sure you and I had this conversation that you know that you have to follow every single rule exactly like they say, okay?
Okay.
And this will give you a little more freedom to be here locally where you can see family and things like that as well. All right?
All right.
So we'll get the paperwork done. I don't know exactly when all of it will take place, but it'll happen very soon. I am going to find at this time that treatment is still required, but that a lesser restrictive environment is appropriate. And I will set out an order with all of those rules with regard to medication and things like that for you to follow. And as soon as all that's done, they'll work out getting you transferred here. Okay.
Yeah.
You good? Okay. All right. Sounds good. Y'all take care.
Take care too. Good.
Thank you. Let's see, Mr. Burbank. You've got Elazar Stansberry. Hey, Tom, what is it back there that I need to get taken care of? It's Marvin's. Is he here? Yeah, okay. Y'all remind me after this one, I'll take care of him. Stansberry. Thanks. Morning. Morning, Mr. Smith. You know what I think I'd like to do is maybe quarterly require them to bring them here. Just to. Bell, I have to talk about that. I don't want it to slip through any cracks or anything. Good morning. Are you Elazar Stansberry? Eleazar, Mr. Stansberry, this is 26 DCCR 0174. You're charged with the first degree felony offensive murder. Mr. Burbank, what is the announcement?
Filed a rejection. Today's charge, the offer was 40 years.
All right, let me go through that. So, Mr. Stansberry, what you're formally charged with is obviously the first degree felony offensive murder. And that is from November 7th of 2025. And what that means is that if you go to trial and you're found guilty, the range of punishment would be a minimum of 5 years up to 99 years or life in prison. Do you understand? And I have here on the tablet a document that you've signed entitled Plea Bargain Rejection with Mr. Burbank. This shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 40-year term in prison. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to enter a plea of guilty. You understand all of that? And you want to reject that offer and have your case set for trial. All right, we'll get that done. Mr. Smith, is there any reason to believe that that offer would change?
I don't think so, Judge. This is actually Luke's case. I was just covering for him this morning, but by all accounts, there will be no reductions.
Nothing, as far as you know, not waiting on any type of discovery or
I
evidence.
think there's
Got it all.
nothing that's standing out that
Okay.
It's going to.
All right, so I want to make sure you understand also, Mr. Stansberry, that after today, I will not accept this agreement. The only reason I would accept this or something different or better would be because some different evidence or information came to light that your attorney and the state's attorney didn't know at this point. You understand? All right, we'll get it set on the trial docket. Mr. Burbank will begin preparation for trial. Yes, sir. Thank you.
Excellent.
Mr. Lewis, you have Brandon Bonton.
Yes, ma'am.
Brandon.
Like we've got 1, 2, 3, 4, 6 cases. Good morning. Oh, did I miss a whole page? I did. There we go. 1, 2, 3, 4, 5, 6, 7, 8, 10 cases. Good morning. Are you Brandon Bonton?
Yes, ma'am.
And this is cause numbers 26 DCCR 0277, 278, 279, 280, 281, 282, 283, 284, 184, and 0490. And Mr. Bonton was examined for competency to stand trial by Dr. Grimsley. I received that report. I'm going to take judicial notice of the court file in all of the cases. The report is dated April 14th of 2026. The finding in that report is that Mr. Bonton is currently not competent to stand trial, and that inpatient treatment for competency restoration would be warranted. Is there any other evidence with regard to competency?
Not from the state, right?
At this time, then, I am going to find that Mr. Bonton is not competent to
Can I-
stand trial. Hang on, let me say what I need to first, and then I'll let you.
Illuminati, man. I got the government microphone chip in my left knee, my right ain't hollow. I've been to the hospital. I understand the courts, man. George Bush know me. I'm not lying about nothing. I testified and take a lot of take tests. I'm innocent. I got the right to freedom of speech, man. I'm asking for probation 2-year cap. So I can go home today because these people on the Illuminati application on their phone is manipulating the government system through my chip. I do hear voices. I don't take medication, and they force you to take medication and join done behavior center. Coach Lewis know me. I was sitting here. I had an aggravated robbery job. I shot a 9mm 2 times, one doorway.
So, Mr. Bonton, you can
German
go
Daly shot that 45.
Go
Never
back
got
with the
that clip.
bailiff. You can go with the bailiff.
Talk, man. I'm sorry about that.
All right, I'm going to find that Mr. Bonton is not competent to stand trial. Make the
Sacrifice
finding
him, man.
that inpatient restoration treatment is warranted. Order that he be sent to the appropriate facility for a period of not to exceed 120 days from the date he gets to that facility. It's a lot.
Y'all should have been that.
All right, let's see. Mr. Eckhart, you've got Mark Marceau, 3 cases. Good morning.
Morning, Judge.
I think that needs to become a full case.
Right, I'm gonna do it the right way. Very hard. Hey, can I go with my stuff, man? If they rather be murderers than rapists, don't keep their pace, bro. Better a brother, you know, fucking nigga call me. Right. Y'all gotta do your fuck, right?
Good morning. Are you Mark Marceau? Are you Mark Marceau? This is cause numbers 26 DCCR 0396, 397, and 398. Mr. Marceau is charged in 2 of the cases with sexual assault of a child, and the third with continuous sexual abuse of a child. And what is the announcement?
Judge, Ms. French and I spoke last week about this case and about our plan. She's still in the process of obtaining CPS records. At some point in the near future, we're going to file a request with the court for a bond reduction. And those are the two kind of most urgent matters that we've got.
Okay. I don't see that that request has been made yet for the CPS records.
Not yet. I've been preparing for trial that didn't occur yesterday.
Right.
I'll be preparing that.
Okay.
Motion and order, Your Honor, and also, whenever the hearing is for the bond, if I can have a little bit of notice because of the family dynamics here, obviously the state will argue against that.
So what I'll do right now is just do a 60-day reset. Obviously, if you file a motion for bond reduction, we'll move that up immediately to a court date for that. And then we'll kind of push it back a little bit. The CPS records take some time to get. And then, so if you can get that, Ms. French, I'll get that signed this week. And that way we can get that process started. And then we'll see where we are, but we'll move it up for a bond reduction hearing.
Thank you, Judge.
All right, thank you. You can go back with the bailiff.
If you want to look at the video this week, it's a.
Let's see, Mr. Brian Lane,
Yes, ma'am.
you've got Khalil Bradley Harris.
Yes, ma'am. That'll be a plea.
I'll hold it till the paperwork's ready. And then what about Heyman Brandon?
If we may approach on him just for a second. Your Honor, the court allowed me some time.
Let's get Mr. Brandon out here. So he's Heyman Brandon.
Hangman's right.
Yeah, just hold on a second, since he's here.
Okay.
Let him know what's going on. All right, you're Heyman Brandon. And this is 21-36605. Mr. Brandon is charged with murder, and what is the announcement?
Your Honor, we're respectfully requesting one more announcement. The court has reset it today for us to get an insanity evaluation from Dr. Capone. It took me a little while to get to Dr. Capone. I spoke with him yesterday. He said if I'll get him the materials, he could have an evaluation report done within 2 weeks. So if we could just have one more 30 days, I believe that's going to.
My concern is deterioration in our jail because we finally have competency after years of not.
Right.
And so I need that done. This is, I'm going to reset it 3 weeks. We need to have it done within 3 weeks.
Well,
And so
I may be on vacation until the 15th, so.
do you have a vacation letter in? Okay, we'll take that into consideration.
Okay, also, respectfully, if we get the report, I think the state's gonna look at it. If the state wants to move forward, then we're going to ask for a bench trial. We want to set that.
Well, let's see what the report says so that we know which direction we're headed once we get that report.
Oh,
So we'll just set it for an announcement and then that day we'll know for sure what we're doing one way or the other.
Just-
Okay, sounds good. You can go back with the bailiff. Mr. Lewis? Mr. Parker, you've got Donald Cogdale's of sentencing. Donald Cogdale. Cogdale.
Go back for that. No, Aaron is good.
Rashard.
That case is hard for me.
Yeah, same, but
I agree with this.
oh. Yeah.
You put it says on reset. It's a competency. Here.
Yeah.
I don't, I mean. it's-
Jonathan Richard, that's yours, Ms. Malfino, from what I show.
That's weird. Mine shows paying French.
Oh. Oh, well, I don't know whose it is.
That's weird. How are you? West Preston's. There you go.
All right, so are you Jonathan Richard? This is cause number 25, DCCR 0248. Mr. Rashard was charged previously with evading arrest or detention with previous convictions and was found not competent to stand trial and sent to the John Dunn Behavioral Science Center for competency restoration. Received the report from them dated May 4th of 2026. I'm going to take judicial notice of the court's file. The report states that Mr. Rashard has not achieved competency, is not competent to stand trial at this time. There is a trial competency evaluation report, which was prepared by Dr. Turner. And that report is that he is not competent and that current competency restoration treatment would be necessary for competency restoration. In addition to that, there is a forensic psychiatry report from a Dr. Shahani, again, with the finding that he is not competent to stand trial at the present time. Also, there is a physician certificate of medical examination for mental illness prepared by Dr. Shahani. It makes the finding that the patient is mentally ill, and a result of that, they state that he does not meet the criteria for inpatient, but meets the criteria for outpatient treatment because the nature of the mental illness is severe and persistent. As a result of it, if not treated, would deteriorate. In addition to that, there is a second physician certificate of medical examination for mental illness from Dr. Select. That has the same finding that Mr. Rashard is still not competent to stand trial and that outpatient treatment would be warranted for competency restoration. Any other evidence with regard to competency?
None from the defense judge.
So obviously, we all know, and for the record, we do not have an outpatient competency restoration program here in Jefferson County, nor in jail competency restoration. And so I don't have any choice but to order inpatient treatment because we don't have that, unfortunately, here. So at this time, I am going to find, based on those reports, that Mr. Rashard is still not competent to stand trial that inpatient competency restoration placement is necessary because that is what we have in order. Mr. Rashard, for a period of not to exceed 1 year to the appropriate facility for competency restoration. We obviously need to make sure, Ms. Malfino and Mr. Parker, that y'all take a look at the dates on this and how long he has already been in custody. Since it's a state jail felony, we're probably,
Should expire while he's in.
so we need to check those dates. If you'll get that date, if you'll make a note so that we know we can get him back whenever that date hits.
Okay, I'll email.
All right, you can go back with the bailiff.
You can judge.
Mr. Rojas, you've got Manuel Cardinas.
No, it was 12.
Okay. We're gonna reset Sarah Jordan.
Jordan.
Mm-hmm,
And also, Judge, we're gonna ask to reset Mr. Pugh. Willie Pugh.
okay. What's up with that one?
Ashley was gonna.
I just haven't been able to reach the officer yet, Judge, sorry, just 1 week would be.
Yeah, we can be fine.
To ratify off of.
Good morning, sir. Are you Manuel Cardenas Jr.?
Yes.
This is 26 DCCR 0040. And Mr. Cardenas is charged with injury to a child, elderly, or disabled individual. And once you take, okay, let me take judicial notice of the court's file. Mr. Cardenas was evaluated for competency to stand trial. And Dr. Grimsley prepared a report and evaluated him. I received that report. It's dated April 8th of 2026 with the finding that Mr. Cardenas is competent to stand trial. Is there any other evidence with regard to competency?
No, Your Honor.
There.
All right, and will he waive the formal reading of the indictment?
He will, Your Honor.
All right, Mr. Cardenas, in cause number 26 DCCR 0040, you're charged with the third-degree felony offense of injury to an elderly individual from October 13th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $1,000 fine. You would be required to follow all of the rules and conditions of probation, which would also include having no contact or communication with Manuel Cardenas Sr. Do you understand?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Cardenas is not competent?
No, Your Honor.
All right, Mr. Cardenas, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case so that we can make sure everything is covered that needs to be while you're on probation, and then we'll come back later for sentencing. And it looks like the state's already, you're opposed to a bond.
I am, Judge, just due to the nature of the case and the underlying need for that competency evaluation. I have not had an opportunity or have not heard back from Mr. Cardenas Sr. And I would just prefer with that PSI to make sure if there's any APS orders, et cetera, in place, that we have a pretty strict no contact structure. Obviously, that's his father.
Sure.
So it's.
All right, we'll see you back at sentencing. You can go back with the bailiff. Kelvin Johnson, Mr. Rojas, it's a sentencing.
Kelvin Johnson. Kelvin Johnson.
Good morning. Are you Kelvin Johnson?
Yes, ma'am.
And this is 25 DCCR 1781. Mr. Johnson was previously in court, entered a plea of guilty to the state jail felony offense of theft of property with previous convictions. Entered pleas of true to prior convictions, making this a third-degree felony enhanced. The agreement was for a cap of 5 years in prison. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor.
Any additions or corrections?
Not from the defense.
Not from the state.
All right, Mr. Rojas, you may proceed.
Thank you, Judge. Obviously, Judge, when you look at this PSI, what stands out is criminal history. It looks rather lengthy on paper. I'll point out to the court that most of the misdemeanors anyway are trespassing cases. And I would guess, and Mr. Johnson tells me this is the case, that most of those, because he was homeless, didn't have any place to go. And if the court knows if you're homeless and don't have any place to live, you're gonna probably pick up some trespassing cases. He does have 2 prior cases which where he got probation and was revoked. I understand that's not a good track record when we're here asking for probation. I will point out that I think the most or the felony probation case was in 2000. And the one where he was revoked on the misdemeanor was in 2020. So a little bit of time has passed between those two. As far as this current case is concerned, if you look at his statements, he looks like he was stealing food and clothes, necessities. $72 worth, which would ordinarily be a misdemeanor, but for the fact that he already has his 2 prior theft cases, and the other felony case was bumped up to a 3rd degree. He's asking for probation, Judge. And again, the felony history anyway is from the last felony case is from 2003, it looks like 23 years ago. He tells me that prior to being arrested, he was working for a church, getting paid on a daily basis. I also did some work for a car dealership out in Silsbee. He tells me he can go back to both of those jobs. The car dealer, he doesn't have transportation, but the car dealership came and picked him up and brought him back and forth to work. So that shouldn't be a problem as long as that job is still there. According to PSI, he's going to be living with his mom. So we're asking the court to consider probation, a deferred probation term. If the court is not inclined to do probation, I would ask for the minimum term on this 2 years, given the fact that things he was stealing necessities and the length of time since his prior felony convictions.
Thank you, Mr. Rojas. Ms. Malpino?
Judge, I don't think he's necessarily not a candidate for probation. I think it should include safety, in my opinion. If the PSI reads as if he expressed interest in that, I would like to ask him if he really wants to take advantage of that. Otherwise, we're just going to be back here in a year on the same situation.
And I apologize, Mr. Johnson did want to speak to you, just so whenever.
All right, go ahead, sir.
So the first charge I ever got, it was in 99. I did my time. I got out. I had a family. I lost it because me and my wife got into it when she took my kids from Louisiana. I not gave up, but I became homeless. I got all them trespasses. Then I started stealing food and clothes out the store. But being in the county for the months I've been in there, I see it was wrong. You know, one thing about me, I live and learn. But 2 things happened as I was doing what I was doing. I stole out the store and the police came up to me, which they didn't bring me to jail. He told me this one thing. He said, you didn't have to do this. They would have gave you the food and then showed me instead of stealing, I could just X. And then another time I was panhandling on College Street at the burrito place, and across the street was a car wash. And instead of me, and I looked and I thought about something. And I crossed the street and I started asking them to watch their cars. So what I'm getting at that is, it's better to work than to be doing all that. You know, it's a different way that I'm gonna go by doing things this time, you know,
How old are you?
45.
Yeah, time to start doing things
Yes,
different, huh?
ma'am. Yes, ma'am.
Anything else?
No, Judge.
So here's the thing, Mr. Johnson. If I give you an opportunity today, it's probably gonna be, the worst I could do today is give you 5 years in prison if I sent you to prison.
Wow.
You'd be out in 2 or 3 years and that'd be it. If you really want to change your life and you want probation, it's going to be for a longer period of time. And if you violate, the sentence could be for a longer period of time.
Yes, ma'am.
It's going to require safety so that you can have the tools to be successful, to not turn to alcohol and drugs and things like that. So I'm going to kind of leave it to you. If you really want that opportunity, I want you to take it. I'll give it to you today based on, you've been very upfront. Your history is all clearly because of homelessness and drugs. I mean, that's clear. So if you want to change, I'll give you that opportunity. Is that what you want?
Well, probation.
Mm-hmm.
Yes, ma'am.
Okay. So here's what I'm going to do, Mr. Johnson. I'm going to find that you entered your plea of guilty freely and voluntarily previously. Find sufficient evidence to find you guilty, and at this time, find you guilty of theft of property with previous convictions. Find those prior convictions that you pled true to, true. Sentence you to a term of 10 years in the institutional division of the Texas Department of Corrections, but I'm going to suspend that. You'll be placed on probation for 10 years. You'll be ordered to follow all of the rules and conditions of probation.
Yes, ma'am.
That is going to include entering and successfully completing the SafeP program. So you'll go to the inpatient part of SafeP in custody, and then you'll get out, you'll have aftercare. All of that's going to help you find a place to live, get hopefully a job, stay clean, do everything you're supposed to.
Right.
If you do everything you're supposed to, then for all practical purposes, your case here in court's over. You'll be able to serve that 10-year sentence while you're out on probation. But the other side of it is if you violate your probation, I'm going to see all this history. I'm going to wonder why I gave you this opportunity, and you're going to end up with that 10 years that I just gave you. You understand?
Yes, ma'am.
All right, so I'm going to hand you the trial court certification that shows this was an agreement that I followed. So you have waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. Good luck to you, sir.
Thank you.
Thank you. No, fine. Mr. Rojas, you've got Mark Newell.
I'm sorry, who just?
Newell.
Which one do you want to plead? We're going to use.
Good morning. Are you Mark Anthony Newell? And Mr. Rojas, will your client waive the formal reading of the motion?
Here we are.
Mr. Newell, in clause number 23, DCCR 0916, I have a first amended motion to revoke your community supervision. Shows that you were placed on probation July 2nd of 2024 for the state jail felony offense of evading arrest or detention with previous convictions. And that was a 2-year term in the state jail prison that was probated for 5 years. Is that correct? Answer out loud, please. Thank you. It alleges you violated your probation. Count 1 alleges that you failed to work faithfully at suitable employment and provide verification of that. Is that true or not true?
That's true.
Count 2 alleges that you failed to immediately report to the probation officer your address change. Is that true or not true? Count 3 alleges that you provided a urine sample October 29th of 2025 that tested positive for marijuana. Is that true or not true? True.
It's true.
Count 4 alleges that you provided a urine sample March 4th of 2026 that also tested positive for marijuana. Is that true or not true? Count 5 alleges that you admitted to your probation officer that you were using K2 or synthetic marijuana on March 4th of 2026. Is that true or not true? Count 6 alleges that you failed to provide verification of completing the community service hours as required. Is that true or not true? Count 7 alleges that you're behind in your court assessed fees as of March 4th of 2026 in the amount of $2,020. Is that true or not true? Count 8 alleges that you failed to report in person to the Harris County Probation Department February 12th and February 26th of 2026. Is that true or not true? And then count 9 alleges that you failed to report to Jefferson County either online or by mail for the months of May of 2025 and then January and February of 2026. Is that true or not true? Did you enter your pleas of true to counts 1 through 9 freely and voluntarily? Did anybody force you to plead true to those counts?
Just want to get this over with.
Well, so did you plead true to those counts because they're actually true?
Yes.
Okay. I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
This one.
And you fully understand them?
This one.
And you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Newell is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1 through 9 freely and voluntarily. Find those counts true, find sufficient evidence to revoke your probation, and at this time, I'm going to revoke your probation, reassess your punishment in accordance with your agreement to a term of 18 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows that this was an agreement that I followed, so you did waive your right to appeal. You probably already received the other, but just in case, I handed you the admonishment regarding your ineligibility to possess a firearm or ammunition. So because you have a felony conviction, you're ineligible to possess a firearm or ammunition. If you have any questions about that, you can read that document or ask Mr. Rojas. All right. Good luck to you, sir. You can go back with the bailiff. Thank you for being here, ma'am. Rosindo Ooa. Sorry.
It's gonna go counts 2 through 5 on this, Judge. Count 1 is refused.
Thank you. Good morning. Are you Rosindo Ooa? And will your client waive the formal reading of the motion?
He will, Your Honor.
Mr. Ochoa, in cause number 24 DCCR 0367, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation June 23rd of 2025 for evading arrest or detention with a motor vehicle, a 3rd-degree felony, and that was a 5-year deferred probation. Is that correct?
Yes, ma'am.
The state has elected to proceed on counts 2 through 5. Count 2 alleges that you violated your probation by failing to avoid injurious or vicious habits by, oh, no, wrong one. I'm sorry. Count 2 alleges that you provided a urine sample on December 10th of 2025 that tested positive for tetrahydrocannabinol. And is that true or not true?
True.
Count 3 alleges that you failed to provide verification of performing the community service hours required. Is that true or not true?
False.
I'm sorry,
True and false.
how's it true and false?
Because I did community service. I just didn't do it. I just didn't finish.
You didn't finish it, so we'll just do not true then for count 3. Count 4 alleges that you failed to provide verification of entering and successfully completing the moral recognition therapy.
False.
Count 5 alleges that you failed to pay, so you did the MRT program and finished it?
No.
So how's that false?
Oh, true.
It's true that you didn't
True.
finish.
Okay, so,
Yeah, my fault.
okay, so you did not complete the moral recognition therapy. So that would be true, that that was a violation. All right, so count 2 and count 4. Count 5 alleges that you have, are behind in your court assessed fees as of February 18th of 2026 in the amount of $500.
Just now.
That's true. Did you enter your pleas of true to counts 2, 4, and 5 freely and voluntarily? And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Just now.
And obviously you understand if I follow this, then you can't change your mind later and appeal or anything like that. So it looks like the agreement that you've reached is for me to continue you on probation, order a 45-day sanction in our jail, and then you would be back on probation, and hopefully following all the rules and doing better. Is that your understanding?
Yes, ma'am.
All right, then at this time, I'm going to find that you entered your pleas of true to counts 2, 4, and 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to give you this opportunity. So this is your second chance. I don't want you to think you're going to get a third, okay?
Yes, ma'am.
I'm going to order that you serve 45 days in jail. It looks like you probably already have credit for that. You'll get credit for any time that you've been in since this arrest on the MTRP, okay? And then you'll be back out on probation. I do want some type of substance abuse assessment done based on that positive test. If there's something that probation thinks you need to do to make sure that you stay clean, you are going to be required to do whatever that is. Wear a drug patch, go to classes, be in the drop program, whatever. Do you understand?
Yes, ma'am.
All that's meant to make sure that you do better and successfully complete this probation. You still don't have a felony conviction on your record, but you're getting closer to getting one if you keep violating. You need to get that MRT program done. I want it started within 30 days of your release from jail.
Yes, ma'am.
So we're not going to put it off to the end of probation. I want it done. Okay. All right. I'm handing you the trial court certification that shows this was an agreement I followed. So you did waive your right to appeal. All right. Good luck to you, sir. Take advantage of this opportunity.
He just,
Willie Pugh.
that's one we're asking for a week on.
We're just trying to get out ahead of a suppression hearing on that one. Just a quick phone call might
Okay.
alleviate a hearing. And if not, I anticipate probably going to trial due to the offer.
All right. I'll reset it to next week.
He just,
Okay, reset it.
And if it's going to be dismissed due to that issue, I'll do it.
Thank you. Mr. Lane, do you have Khalil Bradley Harris?
Yes, sir.
You can make sure you get that email, the attachment emailed today. Okay. Good morning. You're Khalil Bradley Harris.
Yes, ma'am.
And will your client waive the formal reading of the indictment?
And Judge, with the court's permission, we proceed on the lesser included offense of UCW. My understanding, and I included on the paperwork, that he will enter a plea of true at his parole hearing and be revoked on his parole. We're going to confirm this. And also, if I could just ask, just so that the record reflects to coincide with the previous times we've been in court, I did request Officer Champagne's video for Mr. Lane. It was up front for quite some time. I'll just like for him to advise the court in the record that he did obtain that and review it for his client prior to this plea.
Okay, thank you. All right, Mr. Bradley Harris, the state has elected to proceed in cause number 25 DCCR 1334 with the lesser included offense of a Class A misdemeanor unlawful carrying a weapon. I'm just looking because y'all did state jail felony paperwork. But it's the lesser, so there's just a lot of stuff that doesn't apply on that state jail
Correct.
felony.
It needed
I
to
think-
be done with third degree paperwork.
Yeah, and then written in with the
Yes,
lesser.
ma'am.
I think that's cleaner. I'm gonna delete this. Y'all need to do the paperwork on the TDC paperwork since it's a TDC crime, and then write in the lesser on that one, please.
We have a bad meeting today.
All right, I'll call it as soon as y'all get that new paperwork done. Is charged in all three of those cases with aggravated sexual assault of a child. And what is the announcement? Sounds like there's some information.
Yes, Your Honor, there was some information brought to my attention this morning that I would like the state to look into in regards to Mr. King with contact with anyone. I have spoken with him. He has stated he has not spoken with anyone in regards to this case except for his family,
Right.
like his mom and sister.
So, and you guys can do that. What about just where we are on the case?
I have not yet made an offer. This will give me an opportunity to meet with the family and be prepared to do that in the next setting.
Okay,
30-day reset.
Yeah, I'll do a normal reset. Make sure, Ms. French, if you can get an offer to Ms. Holmes as quickly as possible so she can go over that with her client and the family, since the case is getting already kind of old and he's in custody. So we need to get it moving one way or the other.
Yes, ma'am.
All right, you can go back with the bailiff. This will be the last announcement. And then you have, well, let me do this real quick. Does, do you have something on that? Okay. Do we have some here?
It was mine, Your Honor. He was waiting and messed that up.
Okay, hold on. Yeah. Let's start back at the beginning and. All right, Khalil Bradley Harris. Oh, never mind, I don't have it yet. Would y'all check the tablet, please? Ms. Holmes, you've got Brienne Williams.
Yes, Your Honor.
I mean, I'm assuming.
Good morning, ma'am. You're Brienne Williams.
Yes, ma'am. So it's a bit of confusion on this one. There's a newly indicted case. However, the case was from 2024. And it's my understanding with Ms. Williams that that was addressed when the motion was filed in 2024. But the case had not been filed yet. But she was sent to Franklin House and some other treatments. And now, 2 years later, the case is filed.
It's indicted now.
Yes, it's indicted. So.
Okay, so it looks like there was a motion to revoke. Filed. Well, I've got a order. I don't see the action motion from January of 25. January of last year. No, it's in order. So we need to take a look at this one. I'm missing the motion.
Okay.
There's two orders from 2025, January of 2025, but no motion. So that's, and then there was a motion. Here it is. It's probably because I did this. Never mind. There's a February 18th of 2025. She was here, pled true to counts 2, 3, and 4, and to continue probation with Franklin House count. So the count 1 was that new offense. She did not plead to that one. So what she pled true to was testing positive for marijuana, out past curfew, and behind in her fees. And so it really does not appear that it was taken into consideration, at least on that motion. Now, I don't know that if she's doing well now, that it makes sense with all this time for it to just be indicted for her to, I'm with you on that, I think, Ms. Malfino.
Judge, I don't disagree with Ms. Holmes in the court. I would ask Ms. Chopper Bradley if she has anything to add that would help us unwind this little bit of a.
Well, it appears also that there is a new arrest,
For failure to
Failure to
ID,
ID.
yes.
and so there should be,
Probably
I don't know why there's not an amended motion filed. There should be an amended motion, and there's not, because there's allegation of failure to ID from October 1st of 2025. The arrest for public intoxication from October 1st of 2025. All this is in the administrative hearing dated December 2nd. So I don't, curfew, so it doesn't appear to me that the motion
Yeah.
has anything to do, honestly, with the new case. The motion is, it doesn't need to be an amended, it says what it's supposed to say. So there's a motion that was filed that says failure to ID,
Right.
PI. So we've got that.
Okay.
It does not allege that new offense. We have the new offense, but the motion alleges a different
The
new
failure to ID.
offense. And a public intoxication, 2 new items. So you guys can visit about that.
Okay.
So do you all want to visit today? You
Yes,
need to
ma'am.
hold it?
Yes,
Okay,
ma'am.
I'll hold it. Because obviously those give me more concern than an old one. Yeah, okay, go back with, go to the back. Just. All right, Khalil Bradley Harris, again.
Khalil Bradley here. I'll be in jail.
All right, we're back here. You're again Khalil Bradley Harris.
Yes, ma'am.
And this is 25 DCCR 1334. And I've already gone through with Mr. Harris his plea to the lesser included offense of a Class A misdemeanor unlawful carrying, correct?
Yes, sir.
And so, Mr. Harris, did you enter your plea of guilty to that lesser included offense freely and voluntarily? And did you plead guilty to that offense because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lane?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And are you a U.S. citizen?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Bradley Harris is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of the lesser included offense of unlawful carrying a weapon. Sentence you in accordance with your agreement to a term of 180 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. It's my understanding that part of this is that you are agreeing to plead true in any parole hearing, and then whatever they decide to do is what will happen. Is that your understanding as well?
Yes, ma'am.
I'm going to hand you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. All right, good luck to you, sir. You can go back with the bailiff. Mr. Lewis, you've got Ephrain Dink.
Yes, ma'am.
It's a sentencing. Huh?
Thank you.
Good morning. Are you Ephrain Dink?
Yes, ma'am.
And this is cause number 19-32080. And Mr. Dinkin was previously in court, entered pleas of true, and a motion to adjudicate pled true to counts 1 through 5. And the agreement was for a cap of 10 years. I've received the updated report from probation. Have you both had an opportunity to review that report?
Yeah, they have to.
Any additions or corrections? All
No, not from the state.
right, then you may proceed, Mr. Lewis.
Judge, as far as this situation, Mr. Dinkin, with Mr. Dinkins, we know it's a big ask. He is asking that the court consider keeping him on probation, maybe amending his conditions.
Well, first of all, I can't continue him
Okay,
because his probation expired in 2024. So the only option would be to revoke him, sentence him to time on a straight probation. That's the only option other than regular time.
well, let me rephrase that, Judge.
Okay,
We understand that, okay, even if he is the conviction, he does take the conviction and he goes to a straight probation. What Mr. Dinkins is asking for is the opportunity to get the help through probation that's available to him. He know he is messed up and there's times that he hasn't in the past taken taking those opportunities that was available to him. he's more than willing to try to do that for us, the anger management and the things of that nature. He's trying to better himself. He's a lot older now, you know, to where he can kind of really realize where he is in life and what he wants to do with himself going forward. He knows that probation can help him. He understands that, you know, this, if given that opportunity, it would probably be only one opportunity and it'd be a zero tolerance type situation. And that's what he's asking for, Judge.
All right, thank you, Mr. Lewis. Mr. Smith?
Judge, I would disagree. I think revocation, he had a chance at probation. He absconded. He did nothing. We have no idea what he had been doing for that time. And so I feel like PDC time is appropriate in this case. He was given a chance by his own choices. He believed that.
So, Mr. Dinkin, Mr. Smith went a little light on the chances that you've been given. Because when you were placed on probation back in 2019, started off decent, and then it looks like in 2022, and you were 39 years old in 2019, so it's not like you were young and you've learned something and, you know, you were a kid when this started. You started testing positive for cocaine back in 2022. You were referred to the ATAR substance abuse program, did not comply with all of those directions, so you were given help then. Another administrative hearing was had September of 2022. You tested positive again for cocaine. Even though you had previously been given that opportunity to go through the ATAR program, you had made no effort to enroll in it. So I got a memo, I'm sure, that said to send you to ISF, which I did. And you went through both tracks of ISF, the cognitive and the substance abuse track. And the end of 2022, you got out 2023. You started testing positive for alcohol within a month of getting out of ISF. And you were then referred to the DROP program to help you, even though you had just gotten out of ISF and you never showed up and you've been gone ever since. So I don't know what other options or things we could do for you. You've been given every opportunity to have whatever treatment you need to be able to stay out, take care of your family, as you say. But that's not what you've been doing. So, I mean, you've been gone since 2023. Anyway, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon to a family member. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will be an affirmative finding of a deadly weapon. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. All right, you can go back with the bailiff. Christopher Fair, Mr. Lewis?
Yes, ma'am.
Good morning, sir. Are you Christopher Fair?
Yes.
This is cause number 18-30684. Mr. Fair is on probation for indecency with a child, and there's a motion, a first amended motion to revoke probation. What is the announcement?
Well, Judge, a lot of the situation dealing with Mr. Fair does revolve around some incidents that happened in Walker County. We have been working to try to get that information in. It looks like we are getting some updates as far as, those charges. And on our end, Judge, I would need to ask for a little time just to see exactly where they are. They haven't been indicted for the felony cases. There were basically 2 felonies, 2 misdemeanors. The misdemeanor cases, I have gotten some information on. I have received confirmation that they were accepted as far as the felony cases, just have not been indicted yet, to know exactly what was going on. Right, with
The cases have been accepted, but not yet indicted. And those were felonies that were pending from the same incident.
Okay, so it looks like at least in the motion, we've got a possession of marijuana. We've got an unlawful possession of a firearm by a felon. We've got a possession of drug paraphernalia. And then a failure to drive in the single month lane, no driver's license. Failing to report the arrest. And then several other administrative items, including failure to successfully complete an approved sex offender treatment program, community service, employment, and fees. So contact, and then not reporting by mail or online. So, okay, so let's do this. I'll just do a normal reset, give you guys some time to get a little more information about the Walker County cases. I don't know anything about Walker County or how long things take, but we're not gonna wait forever. So let's see where we are and we can go forward with what we need to, if we need to go forward at
Okay.
see where we are the next.
Thank
day.
you.
All right. Thank you, ma'am, for being here. You can go back with the bailiff. Jermaine Redo. I'll check them after. All right, are you Jermaine Redo? And Mr. Rideau is on probation for aggravated assault causing serious bodily injury and cause number 19-32841. There's a motion to revoke filed, and what is the announcement?
Judge, he has, I believe, maybe 2 due cases coming, in regards to this motion. I know the complainant had went to visit with the DA's office to try to speak with them. I don't have any information on the new cases, Judge, yet, other than what was filed in the motion, to knowing what they all, but.
So these are from February. What is the, Ms. Malfino, where are they in the process?
I'm assuming, Judge, that they're in intake, and I can check.
I'm gonna hold it.
I can check.
We got it. Yeah, let's start checking this stuff before, so we have an idea when we get to docket. I'll hold it. Just go back with the bailiff for a minute.
Okay.
D'Antonio Riggs,
And Judge, before we bring him out,
hold on Riggs.
Hold on, Rick.
Hold on, yeah.
it's one that, it's one of Mr. Nichols' cases that I've been talking to him about. This is one that has some severe mental health issues. Before we place it on the trial docket, I wanted to talk with him about a possible resolution. This is one I think we had only evaluated twice,
Mm,
and he's still coming back competent, but we're, still some issues that, yeah.
okay, all right, we'll reset D'Antonio Riggs. This will be the last reset.
Yes, ma'am.
Harland Roar,
Harland Roar.
This one's no agreement, but he will be in our pleas to the.
All right.
to the motion.
thank you. Good morning. Are you Harland Roar Jr.?
Yes, ma'am.
And Mr. Roar, would you please raise your right hand the best you can? Do you swear or affirm the testimony you give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You can put your hand down. And will your client waive the formal reading of the motion?
He does, Judge.
Mr. Romar, and cause number 16-25644. I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 17th of 2017 for the second-degree felony offense of aggravated assault with a deadly weapon, and that was a 10-year deferred probation. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count 1 alleges that you committed the offense of assault, a Class C misdemeanor, January 24th of 2026. And is that true or not true?
Not true.
Count 2 alleges that you failed to avoid injurious or vicious habits by shoving and pinning Kayla Provost against a vehicle and then ripping the weave off her head on January 24th of 2026. And is that true or not true?
Not true.
Count 3 alleges that you failed to immediately report to the probation officer your arrest by the Port Arthur Police Department for that assault case. Is that true or not true?
Not true.
Count 4 alleges that you were at a location other than your residence at approximately 12:55 a.m. on the 24th day of January 2026. Is that true or not true?
Not true.
Count 5 alleges that you're behind in your court assessed fees and that as of February 16th, 2026, in the amount of $1,373. Is that true or not true?
That's true.
Did you enter your plea of true to count 5 freely and voluntarily?
Yes.
All right, then I'm going to find count 5 true, find that you entered that plea freely and voluntarily. I'm going to reset your case for a sentencing hearing, get an updated report. Obviously, we'll need a little bit of time. I'm assuming you would bring witnesses, this is Mr. Smith.
Yes, Judge, but I looked at it. It should be very quick. We can probably have one witness here as early as next week if you'd like. I'd also note that the complainant alleged in that case was one of my defendants that pled to probation yesterday, so it should be very easy to get her here.
Okay, I might do it on when we have a little, an hour.
30
At an
minutes.
11 o'clock hearing would be fine. If we have it at 11 o'clock, we'll
And
try to do it at that
And I'm
time.
happy to handle it for Mr. Smith today.
Thank you. Yeah, no, just normal reset, because they're gonna do an updated pre-sentence report. All right, you can go back with the bailiff. You do?
Yes.
Mr. Romar, we need his fingerprint.
Fingerprint.
Derek Tinkle.
Oh.
Shinkle.
You give me a stand in on that.
Nah, unless you know something I don't.
I don't. It looks like you got a couple of things going.
It's okay.
Wearing all kinds of hats today.
It's okay. I will advise you in advance. I have nothing to say at this affiliate thing.
Good morning, sir. You're Derek Shinkle.
Yes, ma'am.
This is 25 DCCR 1797. Mr. Shinkle's charged with aggravated assault with a deadly weapon. And what is the announcement?
Judge, this one had been reset because his family wanted to try to hire Mr. West to retain him. I've talked to Mr. Shinkle, and he said that they are pretty much close there to be able to get him retained for the next few weeks to get that done. So, Judge, that's what we was asking for, about 3 weeks.
I feel like last time I said, if you get them hired, great. If not, we need to go forward with something. I mean, obviously, you're the one sitting in jail, but we're paying for you to sit in jail. And so something needs to happen with your case, Mr.
And the court did reset that in February 24th and March
31st for that reason.
Yes.
All right, so this will be the final reset. I'm resetting it 2 weeks. If y'all get Mr. West, great. If not, Mr. Lewis will be out there to visit with you, and you need to go forward with however we're gonna handle your case with Mr. Lewis. All right? All right, 2 weeks.
All right.
April Smith,
April Smith.
it's a, MTRP sentencing.
Yes, Judge. We had the two new cases that was originally part of her motion were indicted like a week.
Oh,
ago.
7 days. Yeah.
Yeah.
Okay.
So,
Yeah.
So we have alternative law.
I was gonna say, we have offers, an alternative offer there. Her husband has came in from Minnesota.
Okay,
He's gonna stay till Thursday to visit with her,
okay,
so we can discuss that. And if we can get maybe a week,
just come back next
come
Tuesday.
back next Tuesday, we'll be able to have it. resolved
Okay,
by then.
we'll reset this to next week.
And just so the court is aware, the offer is safety because a year or two ago, she had a safety warrant that she never turned herself in on. We have had multiple hearings with Ms. Smith where we've all talked about safety and you've given her every step chance below, it looks like. And so my thought was to offer her safety and dismiss the new cases to allow her to go. She said no to that. So my offer is to the state jail, plus plead to a new case so that there is an enhanced. Brienne Williams.
Yeah, I'm not real sure about
If you would-
safety.
if you would
Yeah,
have to-
I'd have to take another look
Right.
at it because based on, the original case was a cat. So
Right,
there's already
right.
been that option with prior felony history, so y'all talk about it, but it's, I'm not saying that's at all. Okay. All right, go back with the bailiff. I'll reset it to next week.
All right, thanks, Judge.
Thank you. Ms. Perazzo, you have Traylon Hill. Bless you. Whoever that was. Good morning.
Sure, I'm familiar with it. I'm looking flags.
Mr. Hill. This is Mr. Nichols. This is Traylon Hill, your Traylon Hill. And this is cause numbers 24 DCTR 1500 1614 1615 0436. Ms. Perazzo, what is the announcement?
Your Honor, we have received a new offer in the case, and if I could have just one more reset so I can visit with Mr. Hill and go over the ramifications of that.
I'm resetting it 1 week. I'll have an announcement next week.
Yes, ma'am.
And it's everything. If he does not want to take that deal, it's going to get set for trial extremely quickly.
Yes, ma'am.
I know we've already talked about, I know you were appointed late. We've gone through some attorneys, but I'm gonna need you to get up to speed quickly. So we'll get an announcement next week.
Yes, ma'am.
Okay.
Yeah, next week, mama. I'm gonna see you in my visit, baby.
Thaddeus McCray.
I just. Was briefed on all. Great. That is good prayer.
I'm sorry, you're Thaddeus McCray?
Yes, ma'am.
And this is cause numbers 26 DCCR 0399 and 21 38959. And Mr. McCray is charged with murder in the first case. There's a motion to revoke probation in the other. And what is the announcement?
Your Honor, there are several items that are missing from discovery. I'm putting a list together and I will be sending that to the prosecutor. Hopefully we can get that resolved quickly.
Okay. And this is Mr. Smith's case. So if you'll get that list together, I know this was just recently indicted and you were appointed just a couple of months ago, but obviously, the sooner the better that we get things taken care of. Get that to Mr. Smith. Let's see where we get. I'll reset it one more time. As soon as Ms. Perazo gets all that information, I'm sure she'll be out to go over it with you, once she receives it from the district attorney's office. All right. All
Thank
right,
you.
you can go back with the bailiff. Have we, is there an, Mr. Salinas? Have we heard from him? Oh, okay, good. What else do I have? Let's see, Ms. Holmes, you've got Paul Malone. Paul Malone. Oh, where'd Ms. Holmes go? Is Ms. Holmes back there? Well, just hold that for a minute.
Well, hold that.
So she's got Mr. Malone, we're holding Brienne Williams.
There she is.
Okay, Ms. Holmes on, Paul Malone.
Yes, sir.
Good morning, sir. Are you Paul Malone?
Yes, ma'am.
And come on up, sir. And this is cause number 20-34762. Mr. Malone is currently on probation for unlawful possession of a firearm by a felon. It looks like that was a 10-year probation probated or 10-year sentence probated for 10 years back on January 19th of 2021. There's been a motion to revoke community supervision. What is the announcement?
Your Honor, I filed.
Oh, I'm sorry, you're here for a bond.
Bond.
You asked us to set a bond. So the allegations in that motion are for a new offense of assault family violence by impeding breath or circulation from Orange County, failure to remain in Jefferson County, failure to report that arrest immediately, failure to never become intoxicated, failure to provide verification of performing community service, looks like violated terms of curfew by not being at his house after curfew, behind in fees, and being on the premises of a place in Bridge City that he was ordered not to be on. So there's this is a straight probation. So Ms. Holmes has filed a motion asking that I set a bond. You may proceed.
Yes, Your Honor. In regards to the allegation of the assault family violence, the alleged complainant calls me every day. She states that she does not anticipate the charges in Orange County to be filed. She did email, and I sent that email to Mr. Nichols as well, in which she went to Bridge City Police Department to request that the charges not proceed and that they be dropped. And she has relayed that to me in regards to that case and her not wanting to move forward with any type of prosecution on the violation of the assault family violence case. I have spoken briefly with Mr. Malone in regards to his whereabouts. If he knows he's restricted to Jefferson County, that he knows he has to remain there, Your Honor. We are asking that a bond be set under the conditions that he's aware. If the court deems a GPS monitoring device necessary, we're in agreement with that, as well as any other conditions to make sure that he abides by any probationary conditions until these cases are resolved.
Miss
I'm
French?
looking at Mr. Nichols' note, and a GPS and a SCRAM device is recommended if the court reduces that bond. And it appears there are several other items that need to be addressed at a hearing on a motion to revoke. But we do have a copy of that email that Ms. Holmes forwarded to Mr. Nichols, and it does appear as though she has gone to the other agency and recanted on those allegations.
Well, there wouldn't be anything to recant if you were somewhere you weren't supposed to be.
Yes, ma'am. And if I'm.
Hang on, I don't want you to say anything you shouldn't say right now, but obviously I've read the email for the record and see what she's saying, but none of that would have happened had you been following your rules of probation. So where would you be living if I set a bond?
At an RV park in Fort Dix.
Which one?
It's behind Tammy's bar. It really doesn't have a name.
Is that on Twin City?
Yes.
Who would you be living with?
Myself.
You own a RV or you would be renting one?
Yes, ma'am. I own. Did get my RV moved while I was in here, so I would have to go get it, but it is in Bridge City.
Is it the new Lloyd RV park?
I don't think so. I think it's right behind, it's right behind Tammy's bar.
Yeah.
What I'm seeing.
No, that's not it.
That's not.
That's the one that shows up when I look, but that's not where that is. Let me look. Let's see.
What is Tammy's? Is that a?
It's a bar.
Oh.
Yeah, it's a friend of mine that owns the property and he has like, I guess, eight or 10 RV spots there. It's not even an address. I can't get mail there or anything like that.
Well, I have to have at least an address. Well, let me do this. What's the address? It's actually Nederland. Tammy's is at 108. I'm sorry, 103 8th Avenue, which is at the corner of Highway 347 and 8th Avenue. So it's right there. Okay. I don't see, do you happen to have in your file, Miss French, the old PSI by chance?
Did we take a look, James?
This is, I guess, old enough to where it's not scanned in.
January 21?
Yes, ma'am.
I do.
Can I take a look at that?
I can hold that for you.
Thank you, ma'am.
Oh, I may have given you something else by mistake there. Thank you.
So it looks like the felony, there's only one felony conviction other than the one he's on probation for, and that was for a drug case back in 2009. That's what I was, okay. All right, here you go. Thank you, Miss French.
There's another conviction, Judge. There's a copy of the court's order down.
Another felony conviction?
Well, that's what he's on probation for.
Oh, right now.
Yeah.
Sorry.
Yeah.
I'm sorry. It fell out of the paperwork.
Oh, that's
I wanted to
right.
make sure.
All right, here you go, Miss French. Thank you. So I'm going to, Mr. Malone, I'm going to grant the motion setting a bond in your case. I am going to set your bond at $50,000. There will be several conditions of that bond. One will be that you have absolutely no contact and no communication with Kristen Proctor. She cannot give you permission to violate that. So she can't say, well, it's fine with me, come over, it's okay. You're violating court order, you'll be back in jail and you will not have a bond. Do you understand?
Yes, ma'am.
That also means communication, not just in person, but it means sending messages or anything like that. None, zero. It also, I am also going to order that you have a GPS monitoring device on at all times, that you remain in Jefferson County, Texas, that you reside at as close as I can get an address. It would be the RV park at the corner of Highway 347 and 8th Avenue in Nederland, Texas. If you cannot move from there without permission or letting us know, you're still on probation. You've got to report to probation. They need to know exactly where you're living and all of that. If you have, where is the RV? Is it at her house?
Yes,
Okay,
yeah, cause when I got put in jail, I didn't think I was gonna be able to get out, so I didn't wanna pay another month, so I got a friend to bring it there.
so that friend needs to bring it back, not you.
Okay.
You cannot go get it yourself. All right, so somebody else has to go get it. You get it to that RV park. And you're not to have anything to do with that, because you would be in violation by number one, being at that house, number one, two, being around her, and being out of Jefferson County, and I'm not giving you permission to do that. Okay? Obviously, if you're not supposed to be out of Jefferson County, you're obviously not supposed to also be anywhere near 253 Kibbe Avenue, okay, in Bridge City, Texas. Anything else with regard to the bond?
No, you're.
All right, GPS. Okay, you can go back with the bailiff. We'll set your case for an announcement.
Oh, no. Oh, did you need him something? Okay. So you have a GPS monitoring device. Session. Now 48 hours of this order. So I think they have put it on police release. I think before you get released, they need to come to jail.
They'll come to jail and do it before.
Yeah, somebody will come, and only.
Yeah, well, you have to get your family to contact them just so that they can come to the jail to put it on.
Something I'm gonna have to pay for, right?
Yes. Okay. What's now, coach?
Hang on just a second, please. While I make all my, before I forget my. Yes, ma'am.
I have the mailing. Yeah.
Oh, okay. Thank you. You can do it on Charlie does it all the time. Okay, yeah, that's fine. It's up to you. I mean, if you can,
I'm fine interpreting it, that's fine.
for something like this, I think that's fine.
Yes.
Okay, thanks. Thank you. Brienne Williams, 2 cases. Ooh, I'm gonna break soon.
So they've agreed to run the requisition concurrent with probation and vertical asset. And the TRP. It's just one's the drug pay that is, you know.
Wait, hold on, I might be getting it mixed up with something else. I need to look at it real quick. What about those other offenses?
She's gonna have to get credit for time served on the state ID, because she can't go to ISF with the pending misdemeanor.
What did we get from St. Peter? Am I thinking of another case?
Yeah.
You may be thinking of Anderson.
Okay. Yeah,
She's on the bench of law.
gotcha. Okay, all right. You're Brienne Williams. Will your client waive the formal reading of the motion and the indictment?
Yes, Your Honor.
This is the offense judge that was from 2024, but just now indicted.
Correct.
And she's done well over, I think, 30 to 60 days on those misdemeanors already.
Okay.
I think they have docket for today.
I'll write down.
Got one more thing, please. The new offenses are from October of last year. All right, Ms. Williams, in cause number 26 DCCR 0531, you're charged with a third-degree felony offense of possession of a controlled substance from November 11th of 2024. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they charged you with? In that case, I have here on the tablets and documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them?
Yes, you.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation, including entering and successfully completing ISF substance abuse track. Which track?
These substance
Abuse.
substance.
Is that your understanding?
Yes, please.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, please.
State tenders number 1.
No objection.
It's admitted any evidence that Ms. Williams is not competent.
No, Your Honor.
I think I want to get an updated report just so that I can have more information before we go forward with all this. So everything, I see everything that's going on that has been going on. So I'm going to find that you entered a plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. It'll give me more information about this case, as well as in that the other one we're about to go through an updated report on probation and what's been going on with especially those misdemeanors that are pending. So then in cause number 18. My goodness, what's that? All right, so in clause number 18-30512, I have a motion to revoke your unadjudicated probation. This shows that you were placed on probation May 20th of 2019 for the third-degree felony offense of injury to a child, elderly, or disabled individual, and that was a 10-year deferred probation. Is that correct? It alleges you violated your probation. Count 1 alleges that you committed the new offense of failure to ID, false or fictitious ID on October 1st of 2025 in Jefferson County. Is that true or not true? Count 2 alleges that you committed the offense of public intoxication October 1st of 2025. Is that true or not true?
Well,
Public intoxication. It means that you were intoxicated out in public, so much so that somebody noticed it and you were arrested for it. Count 3 alleges that you failed to never become intoxicated or under the influence of any intoxicated substance, which is a violation of your probation on October 1st, 2025. And is that true or not true? Count 4 alleges that you were at a location other than your residence at approximately 12:22 a.m. on October 1st of 2025. Is that true or not true? And then count 5 alleges you're behind in your court assessed fees as of December 2nd, 2025 in the amount of $2,398. Is that true or not true? Did you enter your pleas of true to counts 1 through 5 freely and voluntarily? Speak up, please. And did you plead true to those counts because they're all actually true? I also have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Did you also go over these with Ms. Holmes? You understand them as well. And it looks like the agreement in this case is for me to continue you on probation, but order that you enter and successfully complete the substance abuse track of ISS. Is that ISF? Is that your understanding? State tenders number 1.
No objection.
It's admitted. All right, Ms. Williams, in this case, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. Again, I'm going to reset your case for sentencing so that the probation department can do a report on both of these cases that'll give me more information, a full picture of the new case, what's been going on the old case on probation, and then we'll come back and I'll decide at that time if I'm going to follow the agreement and we'll go forward then. Okay? You can go back with the bailiff. Thank you, ma'am.
See about Mr. Man. See you.
What did we do with Jermaine Reddo? Was what Marvin going to talk to him? I held it. I have a note that I held. Yes. Ms. Malfino, have you had an opportunity to check on Jermaine Reddo's stuff yet? Okay, thank you. Mr. Salinas on Carlos Rodriguez.
Yes, Your Honor.
Good morning, Your Honor.
Morning. How are you?
Doing well. Thankfully, it's not raining as hard over here in Beaumont than it was in Houston, so
I think it's coming.
it's coming. Yeah. Was it like El Nino? It's supposed to be a lot of rain coming right now. It's gonna be a pretty bad winter.
Changes good.
Change is good.
Very. Check it out.
All right, and Mr. Salinas, it's my understanding that you're going to translate for Mr. Rodriguez for this hearing. Is that correct?
Right.
All right, sir, are you Carlos Rodriguez?
Yeah, let's go. Let's see. Yes, Your Honor. Let's put it in this video.
All right, I'm good now. Mr. Rodriguez, and cause numbers 24 DCCR 1584 and 1585. You're charged in each of those cases with the second-degree felony offense of indecency with a child by sexual contact. And what that means is that if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison in each case. Do you understand?
Yes.
And I have here on the tablet some documents that have your signature on them that shows that the district attorney's office has made offers if you wanted to enter a plea of guilty for 10-year terms in prison in each case that would run concurrently, which means together at the same time. You have every right to reject those offers and have your cases set for trial. I just want to make sure you understand what the possible consequences are if you go to trial, and what your options are if you want to enter a plea of guilty. And do you understand all of that?
Yes.
And do you want to reject those offers and have your cases set for trial?
Yeah, we. Go to trial.
Okay, we'll get your cases set on the trial docket, and Mr. Salinas will begin preparation for trial. Thank you. Thank you. You can go back with the bailiff. So let's do this. I'm gonna reset Mr. Ritto for just 2 weeks. I don't,
Just read the intake. Just say.
well, I don't know where Marvin went. Is his stuff still here? I don't think so. So Marvin, did we lose him? I think he might have let's just reset it for 2 weeks. That'll give you plenty of time. And if they do have it, maybe they can get them taken care of between now and then. Thank you, ma'am. 21-36585. Sir, you Mark Phillips?
Yes.
And looks like Mr. Phillips is on probation for the 3rd-degree felony offense of unlawful possession of a firearm by felon. And that was a 5-year adjudicated probation. Motion to revoke was filed, and we were here previously. It looks like Mr. Phillips pled true to counts. Let me get that pulled up to make sure. Pled true to counts 2 through 6. Which was positive drug test, admitting to using marijuana, another positive drug test, an alcohol use, failure to attend AA/NA meetings. Entered a plea of not true to count 1, which was a new offense of assault family violence in Orange on October 3rd of 2025. Looks like that new case was refused over in Orange County. I'm assuming there's no witnesses with regard to count 1.
Not based on that.
And so I've received an updated pre-sentence report. He entered those pleas. It was unagreed. Have you both had an opportunity to review the report?
Yes, Your Honor.
Judge, and I've also spoken to Ms. Shagwell about it.
I'm sorry, I can hear you.
I've also spoken with Ms. Shagwell about it as well.
And are there any additions or corrections to that report?
No, Your Honor.
Not from the state unless she has anything.
So I guess I'd like to know, I mean, looks like Mr. Phillips has been to ISF and through an intensive outpatient, but still having issues with regard to clearly substance abuse.
Yeah, I think the main, marijuana he uses it as a coping mechanism, which isn't good.
Well, it's going to get you put in prison, right? You just can't use it as a coping mechanism. You're being given all kinds of opportunities to get the help you need to find more productive ways to deal with stress. I understand there's been a lot of stress within your relationship with your child's mother. It sounds like you're kind of getting past that, which is a positive thing, even though it may be difficult. But, just based on the reading, it appears as though probation isn't completely opposed to safety and giving Mr. Phillips an opportunity. Is that correct?
Yes, ma'am, correct.
Maybe not jumping up and down for it, but not completely opposed to it.
Yes.
Okay. Ms. Malfino? Thoughts
Judge,
on that?
I would defer to what the court deemed appropriate. I know in Mr. Smith's review of it, in the alternative, he thought 5 years in prison would be appropriate, and maybe it would just assist in saying that to the defendant, that if we're back, it will be more than.
Oh, no doubt. I mean, I would assume. I can't obviously say for sure.
Right.
I guess what we're set for primarily today with this time was because we were potentially going to have that new offense.
Right.
Okay. So we don't have that.
Right.
Mr. Phillips, if I give you this opportunity, number one, there aren't any other things to do. You will have had everything we have to offer at that point. If I send you to safety, we will have spent probably over $100,000 on you individually for this help. Do you understand?
Yes.
The opportunity? And I don't want you to go take this bed from someone else and not take advantage of it, because that's what you've done so far. So if you really want this opportunity, then it's time to take advantage of it. And you'll be on zero tolerance. There will be absolutely not a single mistake you can make on probation, or you will be back in here and you will be looking at, was it a 5 over 5 or what was it? No, it was a
I don't
10-year
believe
sentence.
so.
You've already agreed to a 10-year sentence. So we don't even have to have a hearing. No one has to offer anything or say anything. I'm telling you now, you'll get your 10-year sentence. You've already agreed to that. This is a convicted probation. There's no thought process that any of us have to have if you violate again. You understand that? And I'm sure Miss Malfino will make a notation. If we're back here, she'll remind me of that. And I'll have this pre-sentence report that I've looked at, and it won't be good, right?
Yes.
All right, so what I'm gonna do then is find that you entered your pleas of true to counts 2 through 6 freely and voluntarily. Find this counts true. Find sufficient evidence to revoke your probation, but I'm not going to do that. I am going to continue you on probation. I am going to extend your probation for 3 years and order that you enter and successfully complete the safety program. Whatever aftercare probation thinks is necessary, if it's the JCDI program or some other aftercare, you'll be required to do it so that you can continue to make good decisions and get this probation over with. Again, if you do that, then your case here in court's over. You'll get to serve that 10-year sentence while you're out on probation. If you don't, you will be again on the zero tolerance. And that means if you violate, you'll be back in here and you'll be looking at that 10-year sentence, right? Obviously, there wasn't an agreement. You do have some rights to appeal. I can't imagine that you want to do that, but I'm going to hand you this certification that shows, and I need y'all to sign that, and you can give him the bottom copy. Thank you for being here, and thanks for covering.
Yep.
Go.
I'll get these orders and I'll let you know.
Also, and I don't know, I know there was some issues when I read this with the self-medication with maybe some mental health issues. I don't know if there's enough for him to.
We didn't have any proper, like actual diagnosis. It was just more from conversations.
So I don't know if we want to do an evaluation just to make sure that special needs safety wouldn't be more appropriate. It may not be, but if y'all can just look into that.
Okay.
But one or the other. Thank you, ma'am. All right, thank
And I'll
y'all.
get that order. I'll get him to sign it and I'll get it.
Thank you, ma'am.
Thank you. Ryan,
In this tense courtroom hearing, a judge gives a convicted felon one final chance to avoid a 10-year prison sentence after repeated probation violations tied to drug use and failed treatment programs. Mark Phillips appears in court already on probation for unlawful possession of a firearm by a felon when prosecutors outline multiple violations against him: positive marijuana drug tests, alcohol use, missing AA meetings, admitting to continued drug use. The judge reviews his long history of treatment opportunities, including intensive outpatient programs and previous rehabilitation efforts, but makes it clear the court is running out of patience. You can't use marijuana as a coping mechanism. The courtroom grows silent as the judge explains that probation and treatment programs have already cost taxpayers enormous amounts of money. We will have spent probably over $100,000 on you individually. At first, prosecutors argue that a 10-year prison sentence may now be appropriate after so many failed opportunities. But because a newer assault case was dropped, the judge hesitates before sending him to prison permanently. If I give you this opportunity, there aren't any other things to do. Then comes the powerful warning that changes the entire hearing. The judge tells Phillips he is now officially on zero tolerance probation, meaning even one mistake will automatically trigger the full 10-year prison sentence he already agreed to earlier in the case. There will be absolutely not a single mistake. Instead of revoking probation immediately, the judge surprisingly extends probation another 3 years and orders him into an intensive SAFPF treatment program with mandatory aftercare and possible mental health evaluations. This is your opportunity. But the judge makes one thing painfully clear before ending the hearing. If you violate again, you'll get your 10-year sentence. What begins as another routine probation violation hearing slowly turns into a final warning about addiction, second chances, mental health struggles, and how close one defendant came to spending the next decade behind bars. Do you think courts should continue giving treatment opportunities after repeated probation violations tied to addiction? Like and subscribe for more real courtroom moments.